What is a debt buyer? And what should you do if you find out a debt buyer has bought your debt? Should you pay them? We're going to talk about that and more starting right now.
This is Debt Free in 30. Here's your host, Doug Hoyes.
This is show number 256, and it's the last new show of our 5th season. For the month of August, I'm going to record a short introduction and then replay the most downloaded shows of the last season, and then we return in September with all new shows. On today's show, we're going to talk about debt buyers with my guest, Mark Silverthorn. Mark was a guest way back on show number 35. That was in May of 2015, where we talked about collection agency dirty tricks. That was a great show. You can search for it on your podcast app or on YouTube. I first heard the name Mark Silverthorn back in, sometime around 2005, 6, 7. And back in those days, clients would be coming in to see me, and they would bring with them all the invoices, the statements for people they owed money to. And I started seeing all these statements that said Mark Silverthorn on the top of it, collection lawyer. And I thought originally that it wasn't a real person. It was sort of like, Xerox. Well, that's not a real person's name. That was just, the name of the collection agency or something. But there were tons of them. And we ended up doing proposals or bankruptcies or whatever for a lot of those people. And then I think it was sometime around 2010 where you actually called me up and said, hey, by the way, I'm working on a book, and the book ended up being The Wolf at the Door, What to Do When Collection Agencies Come Calling. And I think you actually quoted me in the book when we talked about bankruptcies or something like that.
Yes, I did.
And so there was a shift in what you did from being a collection agency lawyer to not being a collection agency or, basically a collector. So what kind of volume of collections were you doing when you were at your peak? How many times was your name appearing on letters that people like me were seeing?
Oh, it would have been thousands every month.
Thousands, which makes sense because I saw lots of them. So your book came out, was it 2010 that the book came out?
January of 2010.
January of 2010. So it must have been prior to that we spoke, obviously. So we're not going to go through your entire life history. Tell me what it is you're doing right now.
Simply, I represent consumers who are struggling with debt. So anyone who's been sued, anyone who's is having problems making their minimum monthly payments on a credit card, anyone who would like to make themselves protect their income or their assets.
So you're a lawyer.
That's correct.
You're operating as a lawyer here in Ontario. Okay. So if someone is being sued, well, then obviously they can come to you and you can defend them. That's what lawyers do, right? So that's one of the things. And we're going to talk about a court case that you were involved in. But before we do, let's kind of set the groundwork here. Collection agencies. That's what you and I talked about back on show number 35. Can you give me a definition of what a collection agency is? What is a collection agency?
Okay, and I'm going to put this in the context of Ontario and the Ontario Collection and Debt Settlement Services Act. Under that act, there are basically 3 different buckets for collection agencies. Number 1 is the traditional collection agency, and they collect debts on behalf of others, and they do it on a commission basis.
And that kind of makes sense, right? When you think of a collection agency, okay, so I'm a big bank. I don't want to be, and I've got somebody who's now 3 or 4 months behind on their payments. I don't think I can actually collect. I don't want my own people calling and bugging them. So I send it to a third party, a collection agency. They're now going to do the collections. That's what we all think of as a collection agency. Makes perfect sense. You said there's 3 buckets.
The second bucket are debt settlement firms, and those are firms that consumers would hire to negotiate voluntary settlements on their behalf.
Okay. And those were quite prevalent a number of years ago. I'm not seeing as much of them today, probably because the Ontario Collection and Debt Settlement Services Act, which is the act you're referencing, was amended fairly substantially back at the beginning of 2018, right? So about over a year and a half ago.
Yeah, I mean, practically speaking, they've almost been legislated out of business because it's very difficult for them to make any money.
Right. And we've done shows on that before. The gist of it is they are not allowed to charge massive upfront fees until a settlement is arranged. Well, that's how they kind of made all their money in the past.
Right. And now the law is that they can't charge a penny up front, and the maximum fee that they can charge is equal to 10% of the amount of the debt that the consumer originally had that they want to be.
Yeah. So if I had a $3,000 cell phone bill, well, the most they're going to be able to make for settling it is $300. It's really not a whole lot of money, I guess, for them to be back and forth and doing negotiating and so on.
And they can't get that $300 until after the settlement has actually
until it's done.
It's done.
So that could be many, many months in the future. So okay. So that's why we're not hearing as much about debt settlement firms as we have in the past. So three buckets. There's collection agencies, exactly the way we would think about them. There's debt settlement services firms. What's the third bucket?
The third one is debt buyers.
Ooh, that's good because that's the title of today's show. So this works out perfectly. So what is a debt buyer?
Well, a debt buyer is a firm that purchases the debts of others. So, for example, in the court case that I anticipate that we're going to speak about, the Bank of Nova Scotia sold some of its debts to a debt buyer.
Okay, and so let's talk about that then. So again, it's pretty obvious, a debt buyer. So why would, and all the banks do this. You mentioned a specific bank, but they all do it. The credit card companies all do it because I see it. Mm-hmm. If I'm a big bank and I have this debt, somebody hasn't paid on their credit card, let's say. I turn it over to a collection agency. They try to collect. Maybe they don't get anywhere with it. Why would I sell it to a debt buyer?
Well, I'd like to just briefly talk about the life cycle of a debt.
Okay.
Because typically what happens is that a bank, for a period of at least 6 months, their in-house collection department will attempt to collect the debt. And their goal is to get 100% of what's owing.
Which is why when I see this all the time with my clients. So I get behind on the first month payment. No big deal. My credit card statement comes and there's a little note at the bottom that says, hey, you probably forgot to make your payment this month. No big deal. If you've already sent the payment, we're all cool. And then the second month, the note is a little more strict. And I'm getting a phone call now. Hey, where's our money? Where's our money? And that pressure just keeps getting ratcheted up. They at some point are probably going to freeze my account or not allow me to use the credit card anymore. More credit calls, more calls, and so on. So you're saying that somewhere around the 6-month mark is when the original creditor, the credit card company, the bank, whatever, says, okay, wait a minute, we got a big problem here. So what happens at that point?
Well, at that point, it's typical for the financial institution or the credit card company to place the account for collection with a collection agency, and it's done on a commission basis. So that if the collection agency doesn't recover any monies on a particular account, then they don't generate any revenues.
So there's zero risk to the bank. They've been trying for 6 months to collect, couldn't get anything. They send it off to a collection agency. What kind of money can a collection agency make? What kind of commissions are we talking about here? Give me the inside scoop here. What kind of bucks are we talking about?
They can be pretty significant.
So what is that? 10%, 50%? Like what kind of commissions are possible?
Well, I mean, I'm not familiar with the specific commissions on a particular file. I mean, one of your you've had guests on who work for collection agencies. They can give you a much better idea than that, but it's significant.
Okay, it's not insignificant then. So it gets, so we're talking about the life cycle of the debt then. So it goes to a collection agency. What happens after that?
Well, it may be recalled and then sent to another collection agency. So the first time an account is placed with a collection agency, that's called a first assignment. And that may be for 6 months or 12 months. And then typically the creditor, if it's not collected, the creditor will recall the account and place it with a different collection agency, and that's called a second assignment. And this may happen a third and fourth time. And if on the third time, it's called a third assignment. And if it goes out a fourth or a fifth time, that'll usually still be called a third assignment. At some point, the creditor is going to say, listen, let's sell this debt for 5 cents on the dollar or something like that. And then they'll just sell the debt. And they don't sell one debt. They may sell hundreds or thousands to a debt buyer.
So if I'm a credit card company and I've got 1,000 different accounts that I've sent to maybe 2 or 3 collection agencies over the last, 2-year period, perhaps, we haven't collected anything. So at this point, it's like, well, I'm getting nothing from this. If somebody's willing to give me 5 cents for it, I might as well take the 5 cents and be done with it. And that's the thought process, I guess, is it?
Right. And when I say 5 cents, maybe it's 1.5 cents or maybe it's 10 cents, but it's pennies on the dollar.
Yeah, and the debt buyers are pretty sophisticated because they can analyze a list and go, oh, okay, these debts are relatively new. Maybe they're only 18 months old, or these debts are 5 years old. Our chances of collecting are even less, so maybe that's when they're paying 1 cent as opposed to 10 cents. It would be something along those lines. Do they ever... You and I both know that 2 years means something in Ontario.
Yeah, we have a two-year statute of limitations. Now, when I wrote The Wolf at the Door, I indicated that the 2-year clock on the statute of limitations started to run on the date of the last payment. There have been court decisions since then, since 2010, and it looks like the clock starts to run on the 2-year statute of limitations probably somewhere around 6 months or 9 months after the date of the last payment. And that's typically when when the account is charged off and when the creditor treats, for income tax purposes, treats the account as a bad debt and not as an asset.
So just so that everyone understands what we're talking about here, we all remember the old Westerns, right? You can shoot someone, but if 5 years goes by, then they can't charge you with murder. That's not what we're talking about. There is no statute of limitations on murder, I don't believe. And you're the lawyer, you can tell me, but I'm pretty sure there isn't. What we're talking about is, it's called the Ontario Limitations Act. Is that the legislation?
Yes.
And it says that the whole point of it is you don't want to be suing someone for some debt from 15 years ago. The paperwork isn't going to exist. If you're going to sue someone, you got to do it within a certain period of time. So the limitations period, and we're just talking about Ontario here. The rules can be different in different provinces. And we're talking about typical debts. We're not talking about Revenue Canada or student loans or child support or anything like that. We're talking about things like credit cards, bank loans, payday loans, that sort of thing. So the limitations period is 2 years in Ontario, which means you have to commence litigation before the 2 years is up.
Yeah, the real issue is, when does that 2 years start to run?
And so you're saying that there have been some recent court cases that it's not when I stopped paying. It's not when they made the first collection call to me. It could be when the bank says we're sending it to a collection agency. Yeah,
it may be 6 or 9 months after the date of last payment.
So, and how robust are those court cases? Like, if I'm a consumer, how do I know if I'm getting close to my 2 years or not?
Well, I guess, if you're really concerned about whether or not, the statute of limitations has expired, you may want to speak to a lawyer. But it's not 2 years from the date of your last payment.
It's not as simple as that. So now, do debt buyers, in your experience, typically buy debts that are past the limitations period?
Listen, there's one credit card company, I'm not going to mention its name, they buy debts, or they sell their debts when the debts are 6 months in arrears. Mm-hmm. It's a business decision. I mean, there a fair bit of thought goes into, because what the creditors want to do is they want to maximize their financial return on their bad debt portfolio.
Yeah, and if I'm a big bank, and so you owe me $1,000, you haven't paid. If I sell that debt to a debt buyer for 5 cents, I can now write off the 95 cents. My loss is crystallized. Mm-hmm. I can apply that against other profits that I've got. So even though I'm losing 95 cents, I'm getting in effect a tax deduction for 95 cents. And obviously I'm grossly oversimplifying this, but I might as well get the tax deduction this year that I can apply against other income. So that reduces the taxes that me as a big bank are going to have to pay. So one of the reasons they would sell it to a debt buyer is they don't want to be collecting anymore. But the other reason, as you say, there's some financial reasons. We can now write the loan off. We've now got 5 cents, which we can then loan to somebody else. And that's obviously the business that we're in. So can you give me, and again, we're not going to get into too much specifics talking about specific banks and all the rest of it, but can you give me the names of some of the biggest debt buyers that people would be come in contact with here in Canada?
Right. And before I do that, I'm going to say there's 2 types of debt buyers.
Okay.
They're your traditional collection agencies. Many of them will purchase debt. But for your traditional collection agencies, debt buying is always a secondary revenue stream. For a traditional collection agency, collecting money in the traditional sense, where they're collecting the debts of others, that's always their primary revenue stream. So virtually any collection agency could potentially be trying, could have purchased debt that they're trying to collect. But what I'm going to do now is I'll give you the names of some of the firms which I've come across and which I believe are some of the largest debt buyers in Canada. So there's Canaseed Financial Group, CBV Collection Services, CFF Receivables Management, Contact Resource Services, Financial Debt Recovery, MAC Financial Recovery, and PRA Group.
And I've run into all of those names because we see them, because often by the time someone needs to file a bankruptcy or consumer proposal, they're way behind on a lot of their debts. They've already been sold to a debt buyer. So, and frankly, there's nothing wrong with that. Like, we're not here to say debt buying is wrong or right or anything. It's like you say, it's a business decision. Obviously, these debt buyers have a pool of capital, and we understand why the banks would sell a debt, because I can get my 5 cents and write off the rest. And as a debt buyer, if I can pay 5 cents for that debt, and if I can collect 10 cents, I've just doubled my money. So it obviously makes sense if you're a debt buyer and can actually collect. So let's talk about this court case then. And again, we're not going to get into all the details, and I will tell everyone that we are recording this podcast on July the 15th, 2019. It will be, airing before the end of July 2019. But because podcasts are up on the internet, up on YouTube for years and years in the future, if you're watching this in 2021, some of the stuff we're talking about, there may be new legislation, new rules, whatever, that have superseded it. So I want to, be very specific about what we're talking about. So there was a court case, June 11th, 2019. So last month, it was in Guelph Small Claims Court. So can you give us the overview? And again, you don't need to tell me the name of the debtor who was involved, your client or banks or anything like that, but give me the gist of what happened.
Well, I got a phone call 3 weeks before June the 11th, and that was scheduled to be the trial date, which is pretty tight time to sort of prepare. And I'd looked at the defense that my client had put down, which really wasn't going to get us anywhere.
Yeah, the typical defense is, well, I don't owe the money, or they didn't tell me, or something, and that's not going to work.
So I looked at it. One of the things I noticed was that the plaintiff, Canaseed Credit LP, I couldn't find on the Ontario government's website, I couldn't find that they were registered as a collection agency in Ontario. So I thought that was a little bizarre, because I thought that they would have had to be registered as a collection agency.
And just so everyone knows, you can go to the Ontario government website, and it's, is it the Ministry of Consumer and Commercial Affairs?
Government and Consumer Affairs.
Government and Consumer Affairs. And you can do a search for a registered credit counseling agency, a registered collection agency, a bailiff. There's a number of different categories. Mm-hmm. So you click on collection agency, and you can type in the name to see if the person who's phoning you is actually a registered collection agency. So you did that, and in this case, the name did not show up. So what happened next?
So what I did is I brought a pre-trial motion, and because of it was tight time, the pre-trial motion was actually heard on the same day as the original trial date of June the 11th. But I basically sought to have the plaintiff's claim dismissed on 2 grounds. The first ground was that the plaintiff, Canaseed Credit LP, was not registered as a collection agency, and therefore should not be entitled to sue my client. And the second ground was that the plaintiff, Canaseed Credit LP, had not provided sufficient documentation to prove that there had been an absolute assignment of the debt. And I don't want to get into the weeds on this, but let me just say this. It's much more difficult for a debt buyer to sue a consumer than the original creditor, because the debt buyer has to prove that when the original owner of the debt sold the debt, that 100% of the original owner's interest in the debt was transferred. And it's very common for financial institutions, when they sell their debt, to retain an interest in the debt. They may say, we want to be able to recall the debt in certain circumstances. And that makes it difficult, if not impossible, for the debt buyer to be able to sue the consumer.
So if I'm a credit card company, it's pretty easy. You don't pay me, I take you to court and I sue you. And I don't have to prove that, well, I have to prove that there's a debt, but that's pretty easy to do. Look, there's the application form, there's all the transactions and everything. What you're saying is that if I am a debt buyer and I buy that debt from the credit card company, I then have to go to court and convince the court, not only do you owe the money and everything, but also that I have the right to be collecting it. And it's my debt, in other words.
Right. And I'm aware of a number of cases where the debt buyer has refused to provide documents proving that there's been a real sale of the debt. Often these things are characterized as sort of a sham sale because the banks or the credit card companies want control. They want to be able to recall these accounts.
So can a collection agency sue someone?
If a collection agency has purchased a debt, then the collection agency can sue the consumer.
Because they're the original creditor, in effect, or they take this place. But when you talked earlier about what a collection agency was, you said that, well, the typical relationship is they're collecting a debt and they get paid a commission. So they get paid 10%, 20%, 30%, whatever it is for collecting that debt. So if I'm a collection agency and I'm collecting this debt, I've got this 6-month contract with the credit card company, and I want to collect this debt, and I make a bunch of phone calls and you just blow me off. No, I'm not paying. Well, I know you're working. I know you're making money. I want to sue you. Can I do that?
Well, if the collection agency doesn't owe the debt, they could get the permission of the creditor to sue the account, but the plaintiff has to be the entity that actually owns the debt.
Gotcha. So it's the credit card company that's really suing me, not the collection agency that's suing me.
Correct.
The collection agency may facilitate it. So, and that I think is a critical point, because I meet with a bunch of people every week who say, well, the collection agency says if I don't pay, they're going to sue me. And the answer is, well, and I'm pretty sure you talked about this in your book too, The Wolf at the Door. A collection agency, I remember you telling me, and you can correct me if I'm misquoting you, but I think you told me it's something like, well, maybe it's one time out of 10,000 that a collection agency is actually going to sue someone.
Correct. And Doug, I've got to tell you, the number of times when for 12 years, I worked for collection agencies, I might have sent out 1 million letters saying that if you don't pay, I'm going to sue you. And during that period, I might have sued 40 consumers.
So it's virtually never. And one of the reasons is it doesn't make any sense because it costs money to sue someone. You got to have, a lawyer and go to court and serve them with paperwork and everything. And the other reason is, well, these laws we're talking about, that it's the original creditor or the creditor who owns the debt that is actually doing the suing. So let's go back to this court case then. So you went to court. And you said to the judge, well, I think there's 2 reasons why this shouldn't happen. The first reason is they're not registered as a collection agency. And secondly, I don't think they can prove that they have a full and absolute assignment of the debt. Sure, they're collecting it, but is there some, recall provision or something there? So that was the argument you made to the judge. What did the judge say?
Well, the judge agreed with me on both grounds. So on the afternoon of June the 11th, we got a fax from the courthouse saying that we'd been successful on both grounds. And then just a couple of days ago, we got a fax from the courthouse, and the judge awarded my client just under $6,500 in costs. So you can imagine the people down in London, Ontario at Canaseed Financial Group, how upset they would have been where they sued my client for $43,000. Not only did they not get any money from my client, but the court is saying you have to pay my client almost $6,500.
I can see why they wouldn't be too happy about that. So where is the world at now? Now, I understand you have had some communication with the registrar of collection agencies. Is that correct?
Yeah.
So who is the registrar? Like what does a registrar do? I don't care about what their name is, but what do they do?
The Ontario Registrar of Collection Agencies is responsible for enforcing the Ontario Collection and Debt Settlement Services Act, and that act basically regulates the conduct of collection agencies, debt settlement firms, and debt buyers. Now, 13 days after June the 11th, the Ontario Registrar of Collection Agencies sent a letter to the litigants in this lawsuit indicating to them that in his opinion, Canaseed Credit LP was not required to be registered as a collection agency under the Act. Now, that letter from the registrar has no bearing on our lawsuit.
The court's already decided.
Correct.
But do you expect them to appeal?
Oh, they have appealed.
They have appealed. Okay. And one of their grounds for appeal is going to be, look, we got this letter from this government guy saying that we didn't have to be registered anyways, and that was one of the reasons why we lost. So do you think that will be their grounds for appeal?
Well, it would certainly be part of it, but that letter does not provide Canaseed Credit LP with any assistance on the second ground of appeal.
And the second ground was the whole absolute assignment of the debt. Are they the owner of that debt? Is there any other deals where it can be recalled by the original creditor?
Correct.
So stay tuned, I guess, is the answer.
That's correct.
So there will be an appeal. They've already said that that's going to happen. And typically, how long does that take? When does an appeal happen?
Well, it could be several months.
And it won't be in small claims court. Obviously, it will go up a notch.
It'll be in divisional court.
It'll be in divisional court, and obviously they'll have all their facts and reasons, and presumably you will be there to talk to the appeal. So let's talk about the practical then here. So, because we don't know what's going to happen with this specific case. It's going to be appealed. Maybe the appeal is not successful. Maybe it is successful. Who knows? What advice do you give to a consumer? So in particular, let's say that I am a consumer and I get a letter saying, you owe the money, we're going to take you to court. We've already talked about collection agencies. And my advice to someone when a collection agency says they're going to sue you is, well, they probably aren't going to, but they may send it back to the original creditor and they may sue you. Banks sue people all the time. I always say, let's look at the big picture here. If it's a cell phone bill for $1,000 and they're threatening to sue you for it and you've got $1,000, why don't you just pay them and be done with it? Because it's going to show up on your credit report. There's a bunch of negative implications to that. But in my experience, if one creditor is threatening to sue you, you probably have 2 or 3 or 4 other people who you're also behind with. And maybe what we need is a big picture solution here. Maybe you got to look at a bankruptcy or a consumer proposal. Let's deal with everyone. There's no sense having to fight all these different fires. However, let's take the case where, no, that's the only one. That was my only debt, and now a debt buyer has purchased it, or I believe they have, and they're now trying to collect money from me. What advice do you give in that specific situation?
Well, I think anyone who's been sued by a debt buyer should speak to a lawyer, because there's a good chance that if you have competent counsel defending you, that you may win the case if you're sued by a debt buyer. The second point I'd like to make is there may be a lot of people out there who are in the situation where a debt buyer has sued them and got a default judgment against them.
So this is something that's happened in the past. Okay.
And the debt buyer may have put a lien on their house, and there's a good chance that it may be possible to bring a motion to set aside the default judgment, and then the debt buyer may not be able to successfully sue the consumer.
And so even if there's a default judgment, even if there's a lien on my house, it may be possible to go to court and say, hey, take that lien off my house.
Correct.
That's possible.
And one of the other points I want to make is when we talk about dirty tricks, there are some, and I'm not saying all of them, but there are some unethical people out there who work at collection agencies or debt buyers, and they may have arranged to sue people and arranged to get a false affidavit of service, because when you sue somebody, the person that you're suing, they're supposed to receive a copy of the claim.
Yeah, you have to tell them.
But what some unethical litigants will do is they'll go to court, get the lawsuit issued by the court, and they won't serve the defendant, and then they'll put in a fraudulent affidavit of service, like an old address or something, and then claim that the person was served. And how are you going to defend a lawsuit that
you
you're
don't
not
know
aware
about?
of?
Yep.
So there are people out there who've got liens on their home, and they were never actually informed that they were sued.
And I think that's an excellent example of, where you should talk to a lawyer. If you come in to see me and I say, okay, we can do a consumer proposal for you, a consumer proposal does not deal with secured debt. I can't make your mortgage go away if you do a consumer proposal unless you give the house back. And of course, part of the reason of doing the consumer proposal is I want to keep my house. If you have a lien on your house, and it may be from Revenue Canada, it may be from what you just described, someone sued you in the past, the consumer proposal is not going to automatically discharge that lien. It's a secured debt. And so in that case, I would often say, well, you need to talk to a lawyer about that. A deal has to be made with that specific creditor. Now, we've had cases where Revenue Canada's put a lien on your house and we can do a proposal, and one of the terms of the proposal is, okay, Revenue Canada, once you get your money, you'll take the lien off. But in the situation you're describing, where a creditor has sued you in the past and gotten a judgment and put a lien on your house, that's definitely something you want to talk to a lawyer about. A proposal or a bankruptcy isn't going to deal with that directly. So I guess, my advice, and it's kind of echoing what you're saying, is, you want to talk to a competent professional. You want to talk to a lawyer or a licensed insolvency trustee. If you come and talk to me, I'm going to say, oh, you know what? I'm not the person to help you. You need to talk to a lawyer. Maybe you need to talk to a mortgage broker, a tax accountant, whatever it is, depending on your situation. And I know over the years, there have been lots of people who have come to you and you said, oh, you know what? You don't need a lawyer. You need to talk to a licensed insolvency trustee, and then you send them to someone that you know. So I think that's a good piece of advice. There are different situations for different professionals. So if someone is in that situation, how can they track you down? What's the best way to find you?
Well, my phone number is area code 519-987-3270. My email address is Mark, M-A-R-K, A for Apple. My last name, Silverthorn, Silverthorn, @gmail.com. And my firm's website is silverthornlaw.ca.
So we'll put all that on the screen. Well, if you're watching this on YouTube, you will have already seen that, and I will put that at the bottom of the YouTube notes, the link, so that people can find you. And obviously, we can be if someone tracks us down here at Hoyes Michaelis, we can track you down as well. So I think that's good. Are there any final words of advice that you want to give to anybody who's watching today?
I just want to reiterate that if you are sued by a debt buyer, you're in a much better situation defending that lawsuit than if you were sued by the original creditor.
Yeah. An original creditor, well, you owe the money, there are the two grounds that you mentioned in your court case obviously don't exist when it's the original creditor. So, Mark, thank you very much for bringing us up to speed on that today.
It was a pleasure being here today, Doug.
Excellent. Thank you very much. That is Mark Silverthorn, a lawyer who we were talking with about debt buyers and legal action. That is our show for today. That is our final full new show for the 5th season of Debt Free in 30. For the month of August, I will be replaying some of our best, most downloaded shows. I'll record a little introduction about what they were about, so you'll want to catch up on any shows that you've missed that way. Until we return in September with some all new shows, thank you very much for listening. Until next week, I'm Doug Hoyes. That was Debt Free in 30.